What's up, guys? Hope you're all having another wonderful weekend with this excellent weather. I do have a hard stop in a little over an hour to go break down my county GOP booth at the local fair, but we have a topic for tonight, and there's, of course, a lot of topics to cover. We will have our regular weekly live stream tomorrow night to talk about a lot of things, including, of course, the disgraceful verdict in the Trump case in New York and the implications of that, which I could go around and rant for a long time about that, along with a lot of other things going on in the news. Nuclear war, for one, being one thing, and lots of crazy stuff going on in Lansing as well. We have another hideous bill package moving forward, destroying health freedom, which we will cover in depth tomorrow night. But first, we have a new lawsuit that we're going to talk about exclusively in this stream, just to kind of get it out of the way for tomorrow's stream. We got to cover everything else. But yes, there has been a brand new lawsuit filed, this time in federal court, by the same cast of clowns against the target. The defendant in the case is the Kalamazoo County Republican Party. The real target also is the state party, and we'll look at that in just a minute. But let's look at it right now. Actually, we'll get right to it. This is the filing. I don't think the defendants have even been served yet, so this is hot off the presses. But here it is, filed in the federal court in Western District of Michigan, and the plaintiffs are James M. Copas et al. We will see who the et al. Is in just a second here, but of course, James Copas was I believe, the executive director of the state party before he was deputy executive director. So he was in Kristina Karamo's inner circle. He was the foremost author of the Marxist, corrupt, crazy constitution they wanted to implement, which we've been over in previous streams. And of course, their attorney, who is also, by the way, a co-plaintiff, is Dan Hartman, who, of course, was Kristina Karamo's lawyer and the state party's lawyer when Karamo was in charge, but also in her personal capacity, too. So this is the very same people, and we'll look at who the et al. Is in the plaintiff section. And then, again, defendants are Kelly Sackett and the Kalamazoo County Republican Committee. Before we even get into the substance of this lawsuit, let me touch on this bit of news. The New York verdict, I think for a lot of us, was a clarifying moment. It certainly was for me. I have been critical about many things Trump has said and done as president and in the interim since. Things people he has endorsed, for example, and I don't take that back, by the way. But what is that beeping noise? Patty asked. I would love to know that, Patty. I would close. I didn't know you guys could hear that. It's been driving me crazy, interfering with audio recordings I make and all kinds of things. If I knew what it was, if anyone in the chat knows what that beeping noise is, it's coming from some web browser. I guarantee that. Please, I will shut it down. I've got, as usual, a half dozen browser windows open. I thought it was Facebook that does this, but I don't know. I thought maybe it was Telegram that does this, but I closed Telegram. I closed Facebook, I think. But yes, it is driving me bonkers. I'm just going to start closing things willy-nilly here, and hopefully it doesn't screw everything up. The Washington Post, The Guardian. I don't know. Maybe that'll do the trick. We'll see. We'll see if any of those things do the trick. Yeah. Sorry, folks. Sorry about that. Those interruptions. They've been driving me crazy all weekend. But anyway, speaking of interruptions, we are fighting for our lives here. For our country. And they will stop at nothing to rig the election. The beeping is still going. This is really driving me bonkers here, guys. I will close another browser window. Lauren says I can shut off my computer. No, Lauren, it doesn't work that way. I mean, I'm on headphones here. I need to be able to hear. If I turn off the computer on, that doesn't mean it doesn't pass through. It doesn't work that way. But yeah, I am running out of things to close, so I don't know. Wasn't that? Anyway, sorry for the interruptions, folks. We're going to just have to power through this. All that's out the window. All that criticizing Trump now, because Trump wins or we're screwed. There is, I mean, if we even get to the election, Biden might get us into nuclear war with Russia any day now. I don't have Malwarebytes open. I don't have Spybot open. I don't get spy. I haven't had any spyware in years, if not decades. It's not that. It's some stupid website. All right, stop, chat. Please stop talking about the beeping noise. If I could make it go away, I absolutely would. I can't. I've tried closing everything else. There's literally almost nothing open right now except StreamYard and this document in Acrobat. So I don't know what's doing it. Winamp? Could it be Winamp? Closing Winamp. Word? I think it could possibly be Microsoft Word. I don't know. All right. Okay. All right. Well, I know it's fun for you guys, but it's not going to be fun for people watching the stream later. Like, get to the point already. All right. Anyway, we are trying to save our country. And a big part of that is the Republican Party, the county parties, the state party. And this lawsuit, which as we'll look at in a moment, is complete and utter bullshit. But it's going to take time, resources to fend off. And this proves beyond the shadow of any doubt that all these people care about is destroying the party. That is their intention. That has been their mission from day one. That was the purpose of taking over the party in the first place. That was the purpose of their constitution. That's the purpose of all this litigation. They've lost and lost and lost and lost, and they are continuously trying to sabotage the party with these frivolous lawsuits. So here we go. Let's look at it. This is the cover page. Citizenship of principal parties. Nothing checked. Great. Nature of suit. Place an X in one box only. Here's all these different things you can bring federal suits for. Nothing checked. Great. Courts love that kind of guesswork. What's this case all about? Figure it out. Read the suit and figure it out. Good luck. There you go. Origin. Original proceeding. Hey, they checked the box. Is it, though? Is this really an original proceeding, or is this just, we lost at the state court, let's go to federal court and see if we have any better luck there? So here we go. Here are the plaintiffs. James Copas, former executive director of the Michigan Republican Party. Dan Hartman, former general counsel for the state party, and I think even still to this day, counsel for Kristina Karamo. And then you have Rodney Halcombe, Carrie Lynn Eilief, Emily Crawford, Robin Madsen, who are all part of the Kalamazoo Karamo Club. Suing Kelly Sackett, Kalamazoo County Republican Committee. Weird how James Copas is suing the Kalamazoo County GOP and Kelly Sackett, since he's not in Kalamazoo County. He's in Wayne County. Dan Hartman's not in Kalamazoo County. He's in Emmett County. Wonder what they're suing these folks over. And we have apparently two attorneys, Dan Hartman and some other guy, Lester and Turner, who's apparently located right near Dan Hartman in Harbor Springs. Low P number, P21632. This guy must be 80-something years old. Oh, well. Anyway, verified complaint. Now come plaintiffs and state in support of the verified complaint for declaratory relief, 28 U.S. Code 2201, to determine a federal question. And there's really nothing interesting in what those federal statutes are. 28 U.S.C. 1331 is the federal question, says district court shall have jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. Doesn't really say anything. Very vague, total catch-all. And Patty says, I thought we were done hearing these names. Aren't they tired yet? I sure am. Well, question is, when do they run out of money? And I think the issue is Dan Hartman, he's an attorney. He can just file a suit, I mean, the expensive stuff in lawsuits is paying for legal work. When you got some wacko who will just file some gibberish, there's very little court fees. But hopefully hopefully the defendants secure legal fees in whatever judgment comes when this thing gets thrown out. But that's way, way, way ahead of what's happening here, folks. I mean, you never, ever, ever know how a case is going to end up. And you have to defend it vigorously, no matter how stupid it is, period. So this is going to drain money and resources from the state party. who will have to get involved in this case. And of course, the Kalamazoo County Party, who don't have any resources to spare on this. But again, that is what the agenda always was. Is it clear yet, guys? Is it clear yet? We are 5 months from Election Day, and these guys are filing brand new lawsuits to hamstring the Republican parties in Michigan, state and local. Their agenda is to destroy the party. Their agenda is to get Joe Biden reelected. That's the point. If there was no point in this, they would wait till after the election was over. The reason why they didn't is because their mission is to destroy the GOP. Anyway, so again, this is written by the plaintiffs. So this is the way they choose to frame this, not the way any rational person would. We bring this complaint under the First Amendment of the U.S. Constitution for the freedom of association and guaranteed by the 14th Amendment to prevent infringement by the states on the rights to the non-justiciability of certain matters related to an intra-party dispute to be resolved internally by a political party without interference by the government, executive, legislative, or judicial, especially as to the interpretations of bylaws and leadership disputes. Again, that's what they call it, complete BS. This is not a First Amendment issue. This is not a 14th Amendment issue. This is an issue of we got kicked out of the party and now we're butthurt. That's all there is. Yeah, Betty says, I was bewildered the other day when a news station interviewed her when Trump verdicts came in. I was like, seriously, do you mean Kristina Karamo, Betty? I don't know. But that is very, very strange. But again, whose agenda does the mass media serve? Yeah, she says, okay, she says, yes, Kristina Karamo. Why do you suppose the Democrats want to keep Kristina Karamo relevant? Why would that be? Anyway, so now jurisdiction and venue. This should be rich. Pursuant to U.S. Code, the district court has duty to declare the rights and other legal relations of any interested party seeking such declaration, whether or not any other relief is or could be sought. A federal court's jurisdiction over all civil matters under the Constitution, laws which use the United States, commonly known as the federal question doctrine. This case involves the federal question as to the subject matter jurisdiction and justiciability of political party committees by state courts for intra-party disputes of leadership under the federal U.S. Constitution, Article 1, and the Freedom of Association. And the request for declaratory relief raises a federal question that involves substantial federal interest, the First Amendment constitutional right to freedom of association and the non-justiciability of certain intra-party disputes of a political party. We'll see. The request for declaratory relief raises a federal question that involves a substantial federal interest. So they're just basically saying it's a First Amendment issue, therefore it's federal. You know, that's what all this boils down to. The resolution of the federal question will not upset the balance of the federal state authority by creating a flood of similar litigation in federal courts. That was not going to be an issue, but whatever. The declaratory action will limit the use of the newly created contract except. By the way, actually, I should say this won't be a thing because this case won't be. Well, this case isn't going to go anywhere. It could be a thing actually, because what they're trying to do. In fact, by the way, before you even went on the stream, Bethany actually had an interesting take on this. Yeah, they want a federal judge to invalidate all state court decisions, and what these lunatics are actually arguing is that no court can intervene within a political party, which would create a class of citizens literally above the law. That's absurd. Yeah. So actually, if this were to go anywhere, this would be a thing. This would upset the balance of federal state authority. It would create a flood of similar litigation in federal courts. Because now, guess what? Guess what, guys? This is a pass. Suddenly, every single dispute, which is, by the way, it's not within a party, because they're not in the party anymore. None of these people, Jim Copas, Dan Hartman, Rodney Halcomb, Carolyn Eilief, Emily Crawford, or Robin Mattson, are in the Kalamazoo County GOP. So it's actually not an intra-party dispute. And again, fundamentally, their argument will be, well, it is because we shouldn't have been kicked out because we properly removed the chair, which is not true, but that's what they would argue. Well, I mean, think about that, folks. That means anybody could walk into any party event anywhere and say, I'm the chair. They'd say, no, you're not. Okay, well, I say I am, and there's an intra-party dispute, so give me a bank account. I'm using your trade name. I'm taking a bank account. I am doing whatever I want, and I'm calling myself your local GOP because I have the right to. And if you don't like that, well, too bad. It's an intra-party question. It does not work that way. That sounds ridiculous. This is ridiculous. Anyway, where were we? Oh yeah, we were okay. I think we got through most of this. Declaratory action that they're asking for will limit the use of the newly created contract exception. This is what they're saying. They're trying to get out of contract law. Yeah, bylaws are contracts. It's a contract of how an organization is structured among its members. But no, it doesn't apply because you're a political party. So they will create a clear federal application of the First Amendment and has the potential to resolve the matter. To whom? Limiting a flood of state actions for individual interpretation of political party bylaw disputes. There's no flood. There's no flood at the dam that's going to spill over if this case is thrown out by this U.S. court, which is going to likely happen. So here we go. Parties, jurisdiction, and venue. Now, keep in mind, folks, judges are attorneys, law clerks are attorneys. They're people too. And they're going to open this document up. The first thing they're going to see, the first thing they see is, what kind of case is this? They left that part blank. Okay. What's the first thing start about? We want some blah, blah, blah about the Constitution. Okay. But what's the issue? Well, there's a pending state court action. And here's the case number in the state court, which is pending before the Honorable Curtis Bill in the court. So instantaneously, they're going to look at this and they're going to go, oh, we've never seen this before. No, never seen this before. You didn't get what you liked in state court. Now you're in federal court. I haven't seen that one before. The case remains pending, so no order on the issue has been entered. Yet. We'll see how long that lasts. The plaintiff, James M. Copas, is the former executive director who was an officer of the Michigan Republican State Committee, I like how they say former, acting in his official capacity during parts of 2023 and 2024, and at all relevant times which gave to the complaint. Gave rise to the complaint, I guess they mean. No, typo. No big deal. Here's a question, though. How does that explain why James Copas is suing the Kalamazoo County GOP? What beef does he have with the Kalamazoo County GOP? Also, Dan Lawless says executive director is not an officer as defined by the bylaws. True. The plaintiff, Daniel J. Hartman, was the general counsel for the Michigan Republican State Committee, was acting in his official capacity during parts of 2023 and 2024 and all times relevant, which gave to the complaint. The plaintiffs, Rodney Halcomb, Carolyn Eilief, Emily Crawford, and Robin Matson, are putative officers of the Kalamazoo County Republican Committee. Nope. No, they are not. Elected following a special convention of delegates, that was not a convention, held on August 15, 2023, which removed and replaced the County Executive Committee, but which was not legally convened, and which was officially recognized as the rightful officers by a majority vote of the Republican State Committee in an illegal meeting for the purpose of reporting to the Michigan Secretary of State pursuant to MCL blah, 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 as part of Michigan's campaign finance law. The defendants are residents of and located in Kalamazoo County, unlike the plaintiffs, some of them. The defendant, Kelly Second, is the disputed leader of a faction within the Kalamazoo County Republican Party. We'll see. Was the chair of the party elected in November 2023 and removed by a vote of the delegates of the Convention of Delegates and replaced by plaintiff Rodney Halcomb. Yeah, this is all. We'll see. We shall see. By the way, whatever happened in that Kalamazoo County case? I think we're going to hear something about that very, very, very soon. Which brings me back to another one of Bethany's comments from before the stream started. I see two purposes. One, the judge in Kalamazoo is about to rule in the case where these lunatics who are LARPing as the KGOP are being sued for identity theft now. Good. And two, they want their Queen KK reinstated. Yes, we will get to that part too. Also, by the way, Lauren Turner says My thought immediately went to how outraged many have been over Muslims and Sharia, and this wouldn't even be implementing religious law, but whatever the party pleases. Yeah, and by the way, there is a religious element to this, folks. They are a cult. And yeah, it's, hey, the rules don't apply to us because we can do whatever we want because we're LARPing in our sandbox and we can do whatever we damn well please. The Kalamazoo County Republican Committee is, the committee. Yeah, we know what that is. We know what the Michigan. Oh, let's read this because it's also wrong. The Michigan Republican Party collectively provides the county precinct delegates, the right to associate as a county Republican Party. You know, this is important. We've touched on this at other times going through these wackos things, their constitution, all these things they say. They keep coming back to this precinct delegate bullshit. The Republican Party is not just the precinct delegates. And this is where they always get this wrong. Like when they say Kristina was elected by the precinct delegates. No, she wasn't. She was elected by state delegates, not precinct delegates. And there's a reason why they obsess with precinct delegates. And the reason is because that's all they can do. They can't ever win an election, so they'll never be an elected official. But it's easy to just get some friends to file to become a precinct delegate. All you gotta do is file a piece of paper. Most of the time, that's all it takes. And then they can feel special. That's it. But actually, if you think, and this is what they do think, which again is consistent with their mission, which is to destroy the Republican Party. If the Republican Party is only consisting of precinct delegates, then we're done. Because 90% of Republican voters and donors are not precinct delegates, haven't been precinct delegates, don't know what precinct delegates are. Anyway, provides precinct delegates the rights to associate as a county Republican Party, to elect a county Republican executive committee, to elect delegates to a state convention. These are things that precinct delegates actually do. And the plaintiffs all have standing as they are sued by the defendants in state court for alleged breach of contract and torts arising from their political activity in conjunction with either the Kalamazoo County Republican Party or the Michigan Republican State Committee, which is not a party in this case. But that's what they're trying to do, and they think a federal judge isn't going to see right through this bullshit. A federal judge is going to look at this and go, okay, so you're losing in state court, and here you are. And you're not even suing the state party because you want them to bring their lawyers, do you? Federal judges don't give a fuck, guys. They're going to see right through this. And by the way, I mean, I'm half kidding, but seriously, state judges actually do face election from time to time. Federal judges don't. Once they're there forever. So they don't give a crap. And they don't like having their time wasted. Anyway, factual allegations. There's a precinct delegate cycle. Blah, blah, blah. This is all just going to be this is their warped history of what happened in the party and in Kalamazoo. So this goes on and on, and this is all a retelling of what happened in the Kalamazoo case, which we've been over in previous streams. Certain members of the Kalamazoo County Party filed a lawsuit against Kelly Sackett and the Kalamazoo County Republican. But yeah, plaintiffs in this case, plus Sabrina Pritchett Evans, who, by the way, is now running for sheriff. And there's the case number, resulted in his granting a motion for summary disposition in favor of the defendant, Kelly Sackett. Stating in his order, oh, here we go. Here comes the spin. Stating in his order, essentially, that although Kelly Sackett and the Kalamazoo County Republicans Committee did in fact violate the stated in his order, essentially. Uh-oh. Hope that essentially part's not dishonest, because we've looked at that case, and that's not what the judge said. The judge does not say that they violated the bylaws. The judge said, it looks like there may have been a bylaws violation, but that's not what you brought, and therefore get lost. That's what the judge said. The judge, I mean, I can pull this up if you guys want to see it. But this is let's see here. Where do we go? Is this the order? Let's see here. This is the judge's order. Let's see here. Yeah, here we go. This is what the judge actually wrote. The more challenging question concerns whether there is a contractual claim based on a clear violation of the bylaws and the removal of Mrs. Harris. As discussed here and above, this is not part of the plaintiff's complaint. That's what the judge wrote. Judge wrote, interesting question. I'm not going to answer it because you didn't you didn't ask me to. See ya. Maggie Kurzweil, an attorney, says this is a verified complaint by Dan Hartman. I would go after him for serious sanctions in misrepresenting the court's opinion. Yep. That's a problem. That is a problem, folks. And here's the question that they ask. With clear overreach by the chair, the question becomes whether this is internal politics as defined by O'Brien and his progeny. This is a question that not only governed in the bylaws, but also directs in substantial nexus the potential nomination and described here and above. And again, so they're cherry picking quotes from this decision, which are still not saying what they say it said. In dicta, by the way, dicta is lawyer speak for, by the way, doesn't really matter, but just by the way. In this instant case, the plaintiffs do not assert a claim of breach of contract by Kalamazoo GOPs of the bylaws. However, it must be noted that Michigan has recognized that contracts can be formed in the application of bylaws. In Yada case, the Michigan Supreme Court decided a case where the plaintiff pleaded a claim for breach of contract, arguing the defendants breached the bylaws. Even though in the instant case, plaintiffs did not assert a breach of contract claim, it is possible that a breach of claim involving KGOP's breach of bylaws would be adjudicated by this court. This would only be true if the question was not one of internal political decisions, emphasis added. Omitted, you didn't ask this court to assess a breach of contract claim, so we're not going to get into it because you didn't bring it. Oops. And there again, the quotation we just now read. So they go on now. The defendants have harvested the contract theory and ignored the limitation he recognized in his comment, which is clearly dicta, as he was making a comment about unpled claims and possible theories that were not raised by the parties. Oops. But his final comment was clear that he understood the question would not be justiciable by a state court. Wrong. That is not what he was saying. He was actually saying, yeah, maybe if you boneheads had argued this question of contract violation, we might get to it, but you didn't. So the only question you're asking me to adjudicate now is who's in charge of the party, and based on this, it's an internal question. So they are going to federal court to try to rectify their own failings at state court, not just because they didn't like the outcome, but because they failed in their pleadings. Political parties can have intra-party disputes. Duh. There should be challenges, dissent, and discussion. Duh. The ultimate power of the political party is delegated, in all caps and with a space in there for some reason, from the election of precinct delegates who form conventions and determine who will govern them. Again, they're obsessed with precinct delegates. Hey, who elects the chair? In my county, the precinct delegates don't. The executive committee does. So that's this principle of indirect power, you know? Like when our country was founded, we didn't have direct election of U.S. senators. We delegated that to the states. Elected people, elected higher elected officers. Since the executive committee was unwilling to listen to the delegates' grievances, there's a missing apostrophe there. Who cares? They don't have to. The delegates determined that they would exercise their inherent power of self-governance and invite everyone to a convention of delegates to determine if they should reform the executive committee. Too bad it doesn't work that way. Oh, I don't like the result of the 2020 election. We'll have another election. Can't do that. Can't do that. Well, power is inherent to the American people, right? Why can't we just have if we don't like the result of the presidential election, let's just call another one. Doesn't work that way, folks. And again, this is all going to be very, very, very easy to explain to a federal judge who does not want to be bothered by this garbage. There was a call to convention by the delegates, which included invitations to Sackett and crew. Very nice formal writing they have there. To determine if they're, and by the way, this actually, this drips of contempt. Sackett and crew. To determine if there would be removal by the ultimate authority, the delegates. Nope. The delegates delegated that authority to the executive committee who they elected. And again, folks, imagine, what's the purpose of elections anymore? Oh, in my company, we have, board meetings where we have elections of board members. If you don't like what the board does, we'll just dissolve the board and elect a new one. Nope. Does not work that way. Yeah, Patty says, keep voting until you get the result you want. Sounds like someone I know. So now here's where they just claim falsely. They met and had at their illegal meeting, and then they elected a new executive committee and removed the 2022 executive committee. And their new committee were these officers. By the way, I have no idea how many precinct delegates were present at this convention. Doesn't matter. Doesn't matter if there was more at this convention. Doesn't matter whether or not that's a majority. It was an illegal meeting. This convention was an option provided for in Robert's Rules of Order. Doesn't matter. Parties are not governed by Robert's Rules of Order. They're governed by their bylaws. No other political solution was available since neither the 4th District Committee, which has no jurisdiction over the Kalamazoo GOP, nor the Michigan Republican State Committee, who has no jurisdiction over the Kalamazoo County GOP, had been delegated authority over any county committee in their bylaws or any mechanism to resolve other disputes. Good. Again, this proves, folks, how dangerous these psychos are. Remember, they wrote a constitution. Jim Copas wrote a constitution to allow the state party and district committees to have supremacy over county committees. Even though, by the way, in some counties like Wayne, the county is larger than the district in Oakland. And even if that wasn't true, they are not a parent organization. So much for this local control stuff, right? We want a dictatorship. That's what they fought for and lost, thank God. This executive committee formed as the legitimate Kalamazoo County Republican Party, according to them. And then in November, which they'll come to court, having lost in Kalamazoo, having lost in Grand Rapids. And yeah, so legitimate according to whom? Yeah. What? Wait, what? The district committee doesn't have jurisdiction over the county committee? I had no idea. Yeah, these people are all completely nuts. They have no idea how the GOP works because they haven't been involved because they're not Republicans. Yeah, Margaret says the Communist Constitution would have removed all autonomy of the county chairs. I have never, in 16 years in GOP politics, ever had the state even attempt in the slightest manner to intervene in a county party business until Karamo showed up. She's obsessed with it. They're all obsessed with it because they're commies. They're dictators. They're a cult. So they petitioned the state party for recognition as the official county party, which they did not get except from the Karamo cult in their illegal meeting. And so now they rehash their history with their illegal January 13th meeting. And again, this is all easily debunked. This is all of this is completely ruined by the entire history in the Kalamazoo and the Kent County cases. During that vote on December 13th, Kristina Karamo did not vote because the matter was clearly decided. What? Wait, first off, wait. What are we talking about? December 13th? What meeting on December 13th? Oh, January 13th. So the illegal meeting, the LARP fest in Houghton Lakes. Hartman did not because the matter was clearly decided. And Hartman did not. Hartman abstained. Weird, because he voted in the January 6th meeting. But he didn't vote in the January 13th meeting. Weird. Further, James Copas did not have voting rights as an executive director. None of these other people did because they were not recognized and did not participate. There you go. Pursuant to that action of the state committee at the illegal meeting, James Copas sent a letter to the Secretary of State informing the state. informing the state. This is like when tax protesters inform the IRS that they don't have to pay taxes. Yeah, good luck. Good luck. Sent a letter to Jocelyn Benson informing the state who the Michigan Republican State Party recognized for compliance with state campaign finance laws, attached as Exhibit 5. Do we have exhibits here? I don't know if we do. Let's see. We do not. We don't have exhibits. Too bad. That would have been funny to read. I think we've read this in previous streams, though. Kelly Sackett brought a lawsuit before Judge Bell and cited the dicta in his opinion as the ability to bring the cause of action as a contract breach, claiming the bylaws were a binding contract on the members. Plain attached Exhibit 2. Okay, so she's citing dicta, but it's because it's a simple, obvious fact. Yes, your bylaws are your contract of organization. That's what bylaws are. That's why they're called bylaws. They're the laws within laws by the by, like as in within our organization, our company, our informal association, as it were. Kelly Sackett also includes in her cause of action intentional torts in count 3, torts interference with the business relationship, count 4, obstruction of justice and fraud, count 5. Good. Yeah, like real things. The entire basis of the 3 counts of intentional tort rely upon the actions of the officers, ex-officers, LARPing as the Kalamazoo County Republican Committee following their fake election, and the letter to the Secretary of State following the January 13th action of the Michigan State Republican Committee. Simultaneously, here we go, there is another cause of action in Michigan related to bylaws disputes that was brought before Judge Rossi of Kent County, circuit case number yada yada, brought by a group of plaintiffs claiming that Kristina Karamo was removed as the chair at a meeting on January 4th. Claiming now officially agreed by the court because they've won the case. So a case that has now been decided that indeed Karamo was removed as the chair at a meeting on January 6th. And Judge Rossi did indeed interpret the bylaws on a bylaws interpretation as part of a breach of contract claim and issue a permanent injunction in equity, barring Karamo retroactively to January 6th from acting as chair of the Michigan Republican State Committee. Yeah, I mean, disproving their case, nullifying it. Yep, hey, here we are. Your entire meeting on the 13th was illegal, therefore nothing there actually has any force or effect. All null and void. This issue resulted in a preliminary injunction. I'm sure they loved attaching that. The matter is pending a final order by Judge Rossi following the court granting a motion for summary disposition, saying there was no genuine issues of factual disputes to be resolved by the jury demand and entering a permanent injunction. And there you go. Transcript of decision. I'd like to see that transcript. If someone's got it, please send it to me. That's a fun reading all by itself. And C. The defendant, Kristina Karamo, has asserted by earlier motion for summary disposition pursuant to MCR yada yada that the circuit court lacks subject matter jurisdiction under the Non-Justiciability Act. Okay, so blah blah. So all things that the court disagreed with. Just so you know, Judge, Mr. Federal Judge, these are all the things that Karamo argued that the court said, no, this is all BS. And Karamo also disputed the factual claims and interpretations of the construction of the bylaws. Well, too bad the court said that there was no legitimate factual dispute. And also disputed the interpretations of the construction of the bylaws on their face and continuously asserted that Judge Rossi lacks the authority to overturn the interpretations made by the majority of the committee, who on January 13th declared the January 6th an improper meeting, and accepted the January 8th, 2024 report of this policy subcommittee and their interpretation of the bylaws and facts leading up to January 6th. Judge Rossi also stated that the minority faction of the state committee used sharp elbow tactics to legally overcome the will of the majority. Yes, that's called being smart. That's called knowing bylaws, knowing procedure, knowing the rules, knowing the laws, and using them effectively. If you hadn't been stupid, Kristina Karamo people, they wouldn't have been able to win. But you were dumb. So a minority was able to defeat you. Because you didn't follow the rules. Because you didn't know the rules. Because you're dumb. The court denied the motion for summary disposition with an oral opinion attached to Exhibit 6. The circuit granted plaintiff's motion for summary disposition. Judge Rossi has invited appellate review. His remarks on the record ruling. Transcript is pending. So this is supposed to mean that the judge wants to hear this case? Oh, hey, federal judge. Judge Rossi actually wants you to look this over. Sure he does. Yeah. By the way, why did you think a judge would invite appellate review for a case? Because he knows they're going to look at his decision and say, yep, spot on. Right on the money, Judge Rossi. You got it. That's why he's inviting appellate review. Also, Hillsdale County had a dispute and conducted 2 county conventions in November 2022 with different factions. This is material why. This is about the part where, if they haven't already, the judge and the staff's eyes start glazing over. The dispute was brought by the state committee leadership and all of this. Again, all of this stuff. Judge rules this. Judge says that. Decision here. Court case here. Court case there. All this is to the people reading this suit. All of them are going to go like, oh, I see. Didn't get the result you wanted, so now you're here. You lost in the lower courts. You lost in state courts. You lost in this court. You lost in that court. You lost here. You lost there. And now you're here. Got it. The dispute was brought to the state committee leadership in 2022 under Chair Ron Weiser and resolved in favor of one faction through credentialing through the delegates to attend the This is what they're hearing now as they're reading this. They're hearing Exhibit 8. The court should show cause non-partisan. That's all they're reading as they see this. This is a bunch of gibberish, basically. I mean, it's not gibberish, but they're going to say, okay, and you're saying this and this and this. This all has to be taken seriously by the answer. But for our purposes and what's going to actually happen in the real world as people read this, this is going through their minds, is what does this have to do with anything? What does this have to do with anything? I'm sure they're going to explain why later, I think, maybe. But until they get that connection, which they haven't made because they're not good at writing, then it's not going to penetrate. So the undersigned, Daniel J. Hartman, who verified this complaint, has been requested to bring cause of action by at least 2 other county committees for bylaw interpretation. Speculation. I mean, what is this crap? He's been requested by at least 2 other county party committees for bylaw interpretation disputes. Dan Hartman, Mr. Big Shot, he's been requested by other county parties to bring more lawsuits. Yeah, because the state court was trying to tell you, hey, stop it. You're dumb. You're wrong. Stop. No. Do more, Dan Hartman. Whole county parties are in this Karamo cult. Guys know we talked about Huron County, Gratiot County, I think is another one. And again, they don't care. They don't care about President Trump. They don't care about winning the election. This is what they obsess with. This is what they go to sleep thinking about. This is what they wake up in the morning thinking about. Is how can we get those bastards who took over who kicked us out of the party so they could raise money and help Trump win. Trump endorsed Pete Hoekstra and never support Kristina Karamo. Not when she first won, and certainly not after she got kicked out. They don't care what Trump's wishes are. They think they know better than Trump. Oh yeah, we're Trump supporters. We don't do a damn thing for him ever, and we know better than he does for who he wants to be the state chair. And we're going to completely hamstring the entire state party with lawsuits and bullshit for the rest of the entire election cycle, with the election less than 5 months away. But we're the real patriots, not these rhinos, not the ones busting their asses to get Trump over the finish line. No, it's us. It's us bringing these frivolous lawsuits. They're going to get all this sorted out just in time for the election. Sure. Anyway, so Dan Hartman was invited to bring more lawsuits. The concept that interpretations of bylaws and leadership disputes is justiciable is opening a Pandora's box that will result in increase in litigation by competing factions of political parties. Randy says they are not Trump supporters. Amen. Amen. If they were Trump supporters or even Republicans, they said, you know what? We can recruit precinct delegates and try again next time. Which, by the way, they're also doing. Hope you guys have gotten your list of precinct delegate candidates and you start talking to these folks. There's some brand new people. And if they're not explained to what the heck is going on, now remember, these people, all they care about is power. Their little fiefdoms in their county parties and overthrowing the county party and throwing anyone that's ever been effective out of the party. And they're coming. So you'd better talk to the precinct delegates because they're going to talk to them if you don't. Betty Nelson says, I appreciate you, Adam, with all the others like Cindy Holland to take the time to educate. Very comfortable and knew what to expect. Yep. However, the past year definitely pulled me back from getting involved. The crazy things I've watched, you're out of all of your minds, and that's not who I want to surround myself with. Best of luck. Hey, Betty, guess what? Nobody likes doing this. I don't like doing this. I don't like having to go to war with these psychos in my local GOP. And we have lost members in our local GOP because that's the point. We have lost good volunteers who say, I can't deal with the bickering and the fighting. That's their job. That's their agenda. If you don't fight them, they win. So if you care about saving our country and our party, fight them because nobody else will fight them for you. This is every bit as important as fighting the Democrats because it is ultimately the same thing. It is the same thing. And as Scott McMahon has gone through in painstaking detail in his articles and his podcasts, this is part of the left-wing operation. So I understand it's not pleasant. It's painful. But if you care about saving our country, you have to fight. And remember, the founders had to fight a lot harder than we ever did. They had to fight with their very lives and fortunes and sacred honor. And they bled to death on the battlefield. We fight by, arguing with people we don't like. And that's a pretty nice luxury that we have. So I encourage you, if you care, I know it's painful to fight through it and not to quit. Because if you quit, guess what? A, there's nobody else behind you to take your place. And B, if you're a leader and you've been a leader and you've brought people into the party and you quit, they're probably quitting too. So you can't just quit. If you are called to save the country, you have to answer the call. Otherwise, you're just quitting. I'm sorry. I know that sounds mean and nasty, but, it's frustrating. If we had more people in our party, we wouldn't have this heavy lift. But we don't, so we do. The political party has always been left to itself to work out its differences internally prior to the abhorrent actions by some members of the Michigan judiciary that decided to disregard the clear federal... Oh, that's great. Oh, that's great. Paging Judge Rossi for your contempt of court memo. You've been described as aberrant or aberrant. I don't know how you want to pronounce it. To disregard clear federal precedent. Is it though? Is it though? Because boy, if the answering parties, the defendants in this case, and maybe some intervening parties who are not named in the suit, but who are clearly going to be dragged into it, might actually point out that this is a maliciously false accusation of the courts where they did not get the outcome they wanted. It's going to make them look very bad. The defendants in this declaratory relief action in their state suit place reliance upon the state court opinion of Judge Rossi that he has subject matter jurisdiction in the matter justiciable, and that's not valid. The defendants in this declaratory action in their state suit place reliance on the opinion of state court Judge Rossi. You should overturn Judge Rossi is what they're saying. You should overturn Judge Rossi. What's this footnote about? Where is that footnote for? They had their powers stripped by Pete Hoekstra, who refused to recognize the secretary and treasurer. That's cut off their authority without complying with the rules and the bylaws for removal. Good. File suit against Pete Hoekstra if you want. Footnote, Angela Gillespie That's now here it's spelled with 2 E's. I would have thought it was like a French name, like Gilles, but no, apparently it's a Greek name. With a, we pronounce that silent E at the end. Gillisy has since resigned. I'm sorry, Patty. I know she's not Greek. Has since resigned in disgust from the state committee and as secretary of the committee, and has not appointed or confirmed a new one because Hoekstra reportedly lacked the votes to confirm general counsel or the finance chair. That's okay. Mike Bishop will do just fine anyway. And also, by the way, interesting. Take note, because I'm taking names. Who is on the state committee who is not voting to confirm the general counsel or finance chair or secretary? Because obviously they don't give 2 shits about Donald Trump either, do they? No, they don't. If they're actively preventing the state party from functioning, they're not Republicans. They're saboteurs. Period. Hope they get a roll call vote next time they have a next time the state committee has a meeting. Have a roll call vote. I want their names. I want them on record. Of course, I've got all their names from all their previous votes at that illegal January 13th meeting. So there's always that. But one thing at a time here. Both of these other circuit judges cited in the dicta Judge Bell's opinion. They like Judge Bell's opinion. So, again, this works great for them, doesn't it? Yeah. All the judges at the state level agree. We're wrong, and the defendants are right. For the purposes of this action for declaratory relief, the outcome of the various disputes is immaterial. The only questions presented for this court is whether the state court will, 1, adjudicate a dispute of bylaws and grant equitable relief based on contract law, and 2, whether a faction of a political party is a leadership dispute is liable to defend actions in a tort based on their failure to recognize as legitimate the claimed leaders of a political committee and actions to which they hold out a claim. Interesting. For a couple of reasons. First, we're now at count 1, which means we are done with the facts. What does that mean? Well, it means they haven't cited very many facts. Main facts are we lost in court, and that's more or less it. And here they're basically saying, also, by the way, the facts don't really matter all that much. Really just, well, here. We want you to declare this. We request this court declare that the organization of delegates of a political party within a county have an inherent right to delegate authority to an executive committee. Again, now, that sounds nice. That could also be taken to be very, very, very broad. Which is, usually cases are kind of like fact specific, like when you have a suit like Hartman versus Austin, right? Which is a dispute about who gets to go to the national convention. Not the same as a question of who is the chair of the state party. Different questions, different set of facts, different circumstances, different bylaws, different election methods, different issues, So I guess in this case, that sounds so vague. An organization of delegates. First of all, what organization of delegates? Because to me, the executive committee is the organization of delegates with the authority to run the county party. But the delegates, and again, they don't say it. They mean precinct delegates. They're wholly precinct delegates. But the delegates may, when they choose act with the convention, act to remove authority. Yeah, anybody can call a convention, apparently. That's all that matters. Anybody can call a convention, anytime. But the county executive committee is responsible. Really? Hey, what about this whole I thought you guys were all about saying the courts have no jurisdiction. And we can do whatever we want in our sandbox. We're a political organization, okay? We're a county party, a state party. We can do whatever we please. No. Now you're asking the court to say that the county executive committee is responsible for holding a convention of delegates to elect county precinct delegates. What? A convention of delegates to elect county precinct delegates. We're going to have a convention of delegates to elect delegates. Oh. To elect state delegates, you mean? Elect county precinct delegates represent the party in certain state conventions and district conventions, including the ones for the formation of district, state, and national committees by the election of members and/or officers. And 2, that a political party committee may adopt bylaws to regulate the conduct of its committee meetings and rules for the conduct of its conventions. Why does the court need to do that? And we want you, Mr. Judge, to declare that unless the committee bylaws otherwise provide for an acceptance of the state laws, that any state law enacted by the state to regulate the conduct of the affairs of a political party as a political party is unconstitutional. Anything at all. Wow. That's a very broad declaration they want the judge to say. Any state law is unconstitutional if it regulates the affairs of a political party. Any at all. The political committee is vested with the final authority to interpret its own bylaws and rules as a political body, free from government intervention. I like, by the way, also how they appear to want to alienate a judge, whether it's a Democrat or a Republican, because every Republican judge will be alienated by all of this, but Democrat judge, that's probably what they're hoping for, is that they'll get a Democrat judge. Oh, this will fuck over the GOP real good. But now here they're appealing to the libertarian impulses that Democrats don't have. Wait. We're going to say that political parties are just totally free to do whatever they want with no government interference at all. Democrat judge won't like that. So great job, guys. Alienate any judge. Great legal work, Mr. Hartman. No political party shall ask for, nor shall any court enter orders interpreting the bylaws of a political committee for any reason. Any reason. We are the judges. We the party. We are the judges, the juries, the executives, and the parliaments. Especially, just in case this, no party nor shall any court, but especially not any claim that the bylaws constitute a contract between members. Yeah, just in case there's any question, the bylaws are meaningless. Okay, there's no bylaws mean nothing. It's just whatever the executive wants to do, the executive can do. And also, by the way, no more lawsuits. No party. We love lawsuits, but in the future, after we win, in this case, in the future, after we win and we get a suit saying that Kristina Karamo is dictator for life, then after that, no party may commence a lawsuit for civil damages based on torts solely for the conduct of political activity in the name of a political party committee when there's a dispute between the factions as to leadership or interpretation of bylaws. All right, guys, it is almost 9 o'clock. And I said I have a hard stop in a half an hour. So I will try to finish this, but I think you guys might get my drift. Margaret says the former train wreck read the bylaws to mean that she could not be removed. Really? Yeah. Statements of law. And okay, we can probably skip over some of this stuff because it's just mangling case law is all it is. O'Brien, Hartman, and Ferenczi. Again, I've been over Hartman a million freaking times. It is not any kind of landmark decision at all. It was a case where one faction that wanted to be national delegates sued another faction that were the actual national delegates, and the court said, this other case you're citing is different, doesn't apply. This case you're citing is different, doesn't apply. This case you're citing is different, doesn't apply. No, the party can figure out who their national delegates are, and they don't need our help. Which is not this issue at all. So, and this goes on. And again, yeah, this is all stuff they argued in Kalamazoo and in Kent County, all the same stuff. Maybe they're citing some slightly different cases, but it's all the same stuff. If you want to read this, tell you what, I will, when I get back later tonight, put a link to this document in the description of this video. And you can read through all the stuff on your time if you wish. I will declare, and trust me or don't, that this is all the same stuff rehashed over and over again. So here we go. Now we get to near the end here. Yeah, this law is settled. Sure it is. That's why we're here in court, right? This law is settled, but now we're asking this court for all these declarations. Anyway, the first controversy. Way to spell controversy. The concept that the non-intervention into internal affairs of a political party doctrine may have an exception to contract was presented in the dicta of this Kalamazoo case. And I don't know by the number whether that was the case. I think this is the case where I believe this is the case where they sued Kelly Sackett, not the other way around. So what are we arguing here? Okay, the contract claim stuff. So this is all again another rehashing of and a misrepresentation of what the Kalamazoo case was. The Kalamazoo case, the judge said, might be a contract claims issue here. Too bad you didn't argue one. So I'm not going to get into one because you didn't ask me to. And it's too late now. It's too late. Sorry. You argued that I should intervene in this because I have the ability to, and it's not. It might be a contract issue. That removal might have been wrong, but I'm not going to get into that because you didn't ask me to. So this statement of law was a significant factor in the precinct delegates led by the Karamo clan into having a fake convention. And while the decision also agreed the judge would not interfere in the internal workings of the party, again, misunderstanding what the judge said because you guys are dumb, led to this also losing again in Kalamazoo. So, I mean, it's almost funny. They might have had a contract claim in the Kalamazoo court. They lost, didn't bring it. Then they get sued for now not being a member of the party and having this illegal convention, and the bylaw says you can't have one, and they lose there too. So they lost in both directions. So now they say the plaintiffs. I assume here now they're talking about the plaintiffs in this case. So, tell me, how does Jim Copas, former executive director of the state party, and Dan Hartman, former lawyer for the state party, have a claim for breach of contract against the Kalamazoo GOP? Oops. Actually, only some of the plaintiffs have that. And yeah. And it's totally okay that some of the plaintiffs don't have a claim. But why is Dan Hartman and Jim Copas plaintiffs in this case? That's an interesting question, isn't it? Isn't that strange? Because according to this document, as we've read it so far, all it needs to do is have these other Kalamazoo butthurt former members demanding that they be reinstated as the Kalamazoo County GOP leaders for all this stuff. What do Jim Copas and Dan Hartman have to do with any of this? The answer, of course, is they're hoping to leverage this to delegitimize Pete Hoekstra as state chair and reinstate Kristina Karamo and say, oh, everything that the state courts have decided up to this point is out the window. Actually, Karamo is still the chair. Do I still have that?
I'm still legally the chair. I'm still legally the chair. I'm the chair. I'm still legally the chair.
Ladies and gentlemen, now that I was removed from the chair position, ladies and gentlemen, now that I was removed from
reality is I'm still the chair.
Okay, I think I've messed up.
Reality is I'm still the chair.
I messed up badly. All right, I got my regular voice back, so that's good. All right, no more jokes with sound effects. I will stop. Okay, all right. I think we're done hearing from Kristina for now. For now, but if this case prevails, I guess she'll still be the chair again.
I'm the chair.
Anyway, where were we? Oh yeah, okay. There is no federal court or appellate state court that has ever applied the doctrine to a political party. Oh yeah, really? I mean, maybe. I would be shocked if never in history has there ever been an issue where someone tried to breach the bylaws of a party and there was no claim to it. That'd be strange, but I don't know. 84. Mindy says that's awesome. Keep playing that.
Still the chair. I'm the chair. Still the chair. I'm the chair. Still the chair. I'm the chair. You know, the RNC unfortunately decided to unilaterally on their website vacate the chair seat.
Right, no more.
But the reality is I'm still legally the chair.
All right, enough of that. No more, Kristina. You're not supposed to say that. You're breaching your Kristina. You're breaching your restraining order or your injunction. Mindy, I actually did this. That was where those clips. I had these sound clips laying around on my mixing board from like months ago. I did this on a live stream. It was very bad. It was even worse than it was just now. Anyways, bylaws are not written as contracts with offer, acceptance, and consideration. Just because they don't have offer, acceptance, and consideration does not make them not valid bylaws. The members are elected to not join after approving the bylaws. Doesn't work that way. It doesn't work that way. When you are in a company and you get a promotion and you become a board member, the bylaws are already there. And there might be votes to amend them or to change them or replace them. But guess what? The bylaws don't just magically disappear every election cycle. Doesn't work that way. Primary case relied upon the defendants. According to them, according to the plaintiffs, the opposing party says this is what they really relied on, which is a real property dispute, which is not an issue that separates. What's the word I'm looking for? It's not a distinguishing issue. Yes, informal organizations can have bylaws, and those bylaws are their rules. And it works for political parties the same way it works for everybody else. The analogy of a contract fails because, unlike the bylaws regulating real estate as a deed restriction to a property owners association, there's no interest in real property present in a political committee. Really? Really? Political parties have no real property? They don't have lists, they don't have data, don't have bank accounts, they don't spend money, they don't have any of those things, they don't have assets, they don't have, I don't know, materials, banners, buttons, literature, things they pay for to print, yard signs. The political party has they have no property. They have no property. The political association, by its definition, is an expression of the will of the collective. The will of the collective. Because ultimate power and the authority granted to the association by the people. We the people. Anyway, this goes on. Blah, blah, blah. I got to start wrapping it up, folks. Okay, but anyway. Even more preposterous is the claim by DePerno and Second that the executive committee can unilaterally amend the political committee bylaws. Where do they get this idea that a board can change its bylaws? Don't you see, folks? Every individual member of the party, every precinct delegate, heck, why not every member of the public? You know, why not every registered Republican? Some states have registered Republicans, and this is a federal issue. Apparently, it's a federal question. Why, in a state that has partisan voter registration, can't every Republican voter have a convention, vote to remove their precinct delegates, vote to rewrite their bylaws, replace their executive committee members, heck, expel their own representatives? Why not? We the people, baby. This abhorrent behavior is then justified as a contractual right. Even if all the contract terms were true, the doctrine that intra-party disputes are non-justiciable would still apply based on constitutional reasoning that we don't care to explain here. Just reasoning. Constitutional reasoning. What reasoning precisely? Figure it out. Just imagine. Margaret says, guess what, Hartman? State and federal criminal law apply to actions of members, officers, and others of a political party. Criminal law does not go away because a political party is involved. Wake up, Hartman. Yeah, he might get a rude awakening one of these days. Defendants also cite a Michigan case, blah, blah, blah. There is nothing in this case that suggests the bylaws of a political party are a contract, but that this somehow changes the constitutional restriction of the court as a state action interfering with the internal disputes of a political party. Again, I've said this before, I'll say it again, just to encapsulate the incredible stupidity of the essence of this entire thing. Their whole argument is that within the political party, it's the Wild West. There is no contract law. There's no fraud. What's to stop anybody from just walking in and saying, I am the leader of the Republican Party? What makes me not the leader? Well, the courts can intervene. The courts can't do anything. There's nothing. According to them, there is nothing. That's what they want. No, the bylaws don't matter. The statutes don't matter. Second controversy, tort claims. There is a second method, which has been tried by the defendants to have courts interfere. Again, this is obviously when you're writing a lawsuit and in any legal document, you're going to want to write in the style that is leading the reader towards your point of view. Of course, everybody does that. We get it. Same thing happens in politics. You always frame your guy in the most positive light and your opponent in the most negative light. But this is way over that line to the point of the judge going, this is bullshit. Tried by the defendants to have courts interfere with the intra-party political activity. Yeah, tried and succeeded. And again, this is remarkably contemptuous of the state courts. Which, there's a federal court, the Western Michigan District, and then there's state courts in Western Michigan. I'll bet the judges, they're obviously one's a federal judge, whoever it will ends up being, and they're state judges. But, there is a legal community, guys, and they do have legal communities in geographical areas. These judges might kind of know each other. You think they're going to just get away with saying shit like this? And the judge is going to be like, why are you bad-mouthing these judges? And by the way, Rossi, I know what his political views are. Judge Bell is a Democrat. So one way or the other, they're going to piss off this federal judge. They're restating this warped view of their history here, and therefore there's like some kind of tort issue going on here. So, okay, we're at the end here. Wherefore, the plaintiffs pray this honorable court I got a cat on my lap now. Enter a declaratory judgment setting forth the clear distinction that under the First Amendment and the 14th Amendment to the U.S. Constitution, that 1, the claim of a contractual breach of bylaws does not, Kitty, hold on. Sorry, Kitty, not now. The claim of a contract breach of bylaws does not permit state court action to interfere into the internal disputes of a political committee or interpret the bylaws. So, yeah. Don't worry. There's no case history of courts ever interfering in party business over contract claims. No, never happened before. Sure. And 2, the claim of a political committee by its members or officers or committee arising from the political activity of members or a faction of members of a political committee does not permit the state court action to assess damages. Yeah. Hey, by the way, Mr. Federal Judge, we just want you to know that do what we want so that we can never, ever, ever, ever again resolve these disputes in state courts. Everything in this kind of stuff has to go to federal court in the future. Okay? Right? You'll love that, won't you? Right? Just take the state courts out of this. We want everything going through federal court. Federal judges love it, given they're giving themselves more caseload. They love that. Love it. And 3, the disputes involved in the complaint and in the state of Michigan and the Circuit Court of the County of Kalamazoo are not justiciable. So beginning to end. The first and last, and by the way, when people read documents, if those of you don't know, if you get a political piece in the mail, a letter, first thing people read is the first sentence. The second most read thing in the letter is the last sentence on the last page. Because what do people do? They get a piece of mail, they open it up, look at the top, flip it over, look at the bottom. So the first and last thing in the document, the thing that they're going to see first and second, front and center, we lost in state court, overturn the state court. Kick this, Kitty, no. Kick the state court out. And that's it. That is the end of the complaint. So there you go, folks. If I was any of these plaintiffs, I would not hold my breath if this case gets anywhere for them, because it won't. But that's not the point, is it? No. The point is, which was always the agenda from day one, destroy the Republican Party. At the critical moment, in the 5 months leading up to the presidential election, keep them busy with litigation, dealing with intra-party fights and squabbles. It's a word for a minor fight, but it's a big fight. This is a serious fight. Keep people obsessed over the precinct delegates who will be elected in August instead of having their eye on the ball, attacking the Democrats. This is an operation. Every bit of it always has been. And if it was not clear to you already, as it should have been from everything we've seen up until this point from Kristina Karamo and her cult, this lawsuit makes it absolutely, utterly clear. They have lost. And if they cared about the future of the party, they would say, you know what? We can revisit this next time. We can revisit this in December. We can revisit this 2 years from now. We can recruit more precinct delegates who will say, you know what? We don't like Pete Hoekstra. We want Kristina Karamo back. We loved having the party being broke and the party having legal problems. But they don't want to wait. And the statute of limitations would go another, several more months. But they don't want to wait because the agenda is to destroy the GOP. I've been saying this for a long time. Scott McMahon's been saying it for longer than I have. That is the agenda. These people, and some of them are state committee members now, are not Republicans. They are not Trump supporters. They are saboteurs. So you better wake up to that. And you better inform your precinct delegates about this too. The ones that are filed now for the upcoming term. Because it will not end. It will not end until they are made to stop. And that's by being defeated in the August conventions. So that'll do it for us for tonight. We will have our regular stream tomorrow night. We will talk about the Trump case and the disgrace that it is. We will talk about national news, international news, local news, state news, lots of crazy stuff happening every which way you turn. But this is my legal stream for tonight. And also, I mentioned this on last Sunday stream. Folks, the idea of reading lawsuits on a stream came from Nick Rekieta, who has been a huge influence on this and many, many, many other shows on multiple networks, YouTube, Rumble. And he is unfortunately in a very bad way. So pray for his recovery and for his family. So I might talk about that in greater length some other time too, because this has become a story of its own. But it's not a story for us for tonight. So as always, guys, thank you for tuning in. Thanks for all you for liberty. More from us tomorrow. And until then, peace.